"You're under oath." Those words should guarantee truth, but what happened next exposed something far more dangerous than lying to Congress. Secretary Noem just defied a unanimous Supreme Court ruling while sitting before the American people, claiming her authority supersedes the highest court in the land. Goldman's response didn't just challenge her, it revealed a constitutional crisis unfolding in real time.
For 5 minutes questioning.
Thank you, Mr. Chairman. I would like to go back to Mr. Kilmar Abrego Garcia's case, Madam Secretary. But my first question for you is a pretty simple one. It's basic civics. Which branch of government does the Constitution give the authority to interpret what the law is, the judiciary or the executive branch?
Sir, going forward, the interpretation of the law, you make the laws in this body. The judicial branch makes sure that they have integrity and they're applied properly to individuals.
So I'm just going to take that as the judiciary branch. Now, let's focus for a second on what the judiciary branch has said about this case. We know the Supreme Court has said 9-0 that notwithstanding your statements under oath here today that Mr. Kilmar Abrego Garcia was afforded due process, he was in fact not afforded due process, because then if he were, you would have seen the withholding order that did not permit him to be deported to El Salvador. Now you allege, and I guess the Attorney General alleges, that he's a member of MS-13. That may very well be the case. And if he is, now that that is a foreign terrorist organization, certainly the immigration laws would allow him, and in fact require him, to be deported. I certainly would support that. But the problem that we have here is what you allege, what Ms. Green alleges, what the Attorney General alleges, is not the judiciary. You don't get to decide whether or not he is an MS-13 member. And you don't have to take my word for it, because Judge Wilkinson, a Fourth Circuit judge, very conservative, addressed this argument. He said, the government asserts that Abrego Garcia is a terrorist and a member of MS-13. Perhaps, but perhaps not. Regardless, he is still entitled to due process. If the government is confident in its position, it should be assured that position will prevail in proceedings to terminate the withholding of removal order. Will you commit right now to give Mr. Abrego Garcia that process where you can prove your allegation that he is a member of MS-13?
Congressman, that judge that you just quoted did not say he was not a member of MS-13. Who did say that he was a member of MS-13 was law enforcement officers that encountered this individual.
Yeah, he knows that. This is a Fourth Circuit judge. He knows all of what the evidence is, and he's saying if that evidence... So you're not going to commit to follow this order? You won't commit to follow this court order?
By the way, he identified
Madam Secretary,
himself.
I reclaim my time. Stop filibustering. Stop filibustering.
By gang members of MS-13.
Will you give Mr. Abrego Garcia the due process that the Supreme Court and Judge Wilkinson has required you to give him?
Abrego Garcia is an El Salvador resident who is in his home country. If he were to come back to this country, he would be immediately removed again.
How do you know?
He has received and been treated appropriately,
so
sir, and he is not.
How can you say he's been treated appropriately if the Supreme Court has ruled 9-0? 9-0 that he hasn't been treated appropriately? Why is your opinion better and have more authority than the Supreme Court?
Investigators, 2 judges, an immigration court that all said he was MS-13 and was removed from this country.
But you understand, that is you saying that. That is you saying that.
That is them saying that. This
no.
investigators and law
that is
enforcement
you making that determination.
Against him. If you don't trust
the court has considered all that. The judge has considered all that, Madam Secretary. And if you would be quiet, because I'm reclaiming my time, you are not following this court order. But let's focus on the court order, because this opinion also says that to facilitate, which the Supreme Court is requiring, is an active verb. It requires that steps be taken. What steps have you taken to return Mr. Abrego Garcia to allow him to get due process?
Abrego Garcia is in his home country.
What
If he were to come
steps
back,
have
your
you
advocacy-
taken?
If your continued advocacy for him were to...
I'm not advocating for him.
Yes, you
I'm
are.
advocating for a
Absolutely.
court order, Madam
Gone to the
Secretary.
mat for this
The
man
court order
who has terrorized
says
people
that
in
you
traffic
must take
with human
steps
beings.
to follow the court order. You are here under oath. What steps have you taken to return Mr. Abrego Garcia pursuant to this court order?
It's got to be extremely discouraging to be one of your constituents. To see you fight for a terrorist like this and not fight for them is extremely alarming to me.
I'm fighting for due process, and that's under the Constitution.
Gentleman's
and you
time
should
has
fight too for
expired.
due process.
The gentleman's time is...
What Dan Goldman did in that hearing room was more than aggressive questioning. It was a masterclass in exposing executive overreach through constitutional law. Goldman didn't just challenge Secretary Noem's position. He systematically dismantled the dangerous precedent of cabinet officials, placing their judgment above Supreme Court rulings. The exchange centers on a fundamental constitutional principle that most Americans take for granted: judicial supremacy in interpreting law. When Goldman asked which branch interprets law, Noem's hesitation revealed everything. She understood the trap. Acknowledging judicial authority would force her to explain why she's ignoring a unanimous Supreme Court decision regarding due process rights for Abrego Garcia. Goldman's strategy was surgical. First, he established the legal framework the Supreme Court ruled 9-0 that due process was denied. Then he quoted Judge Wilkinson, a conservative Fourth Circuit judge, to eliminate any partisan angle. The message was clear. This isn't liberal activism. It's basic constitutional law. Notice how Goldman controlled the narrative tempo. He didn't allow Noem to pivot to immigration talking points, or MS-13 fear tactics. Each time she attempted deflection, he pulled her back with phrases like, "I'm reclaiming my time, and you are not following this court order." This wasn't just parliamentary procedure. It was strategic containment of executive overreach in real time. The legal concept Goldman exposed is called executive nullification, when federal officials simply refuse to implement court decisions they dislike. It's different from appealing a ruling or seeking legislative remedies. It's the raw assertion that executive judgment trumps judicial authority, turning constitutional law into optional guidelines rather than binding commands. Noem's response pattern became increasingly desperate. She deflected to MS-13 allegations, filibustered about law enforcement assessments, and finally resorted to personal attacks against Goldman's constituents. Each evasion only reinforced Goldman's central point. She refuses to follow court orders she disagrees with. The most chilling moment came when Noem repeatedly claimed Garcia has been treated appropriately, despite a unanimous Supreme Court ruling to the contrary. This wasn't bureaucratic stubbornness, it was executive nullification of judicial authority. When cabinet secretaries can simply ignore court rulings based on their personal assessment, the separation of powers collapses. Goldman's final question about concrete steps exposed the administration's strategy: passive resistance to unfavorable court orders. By claiming Garcia is in his home country and would be immediately removed again, Noem admitted they're circumventing the legal process rather than complying with it. The broader implications extend far beyond one deportation case. If executive officials can ignore Supreme Court rulings on due process, what prevents them from ignoring court orders on voting rights, environmental protection, or civil liberties? Goldman understood this wasn't about defending an alleged gang member. It was about defending the constitutional framework that protects everyone. Noem's accusation that Goldman was fighting for a terrorist perfectly illustrated the administration's approach: wrap constitutional violations in national security rhetoric to make opposition seem unpatriotic. Goldman's response: "I'm fighting for due process," cut through that deception and returned focus to core principles. This exchange reveals a systematic erosion of judicial independence. When executive officials publicly defy court orders while under oath to Congress, they signal that compliance with unfavorable rulings is optional. That transforms courts from co-equal branches into advisory, bodies whose decisions can be ignored when politically inconvenient. The historical parallel is unmistakable. Andrew Jackson once allegedly said, "John Marshall has made his decision. Now let him enforce it," when defying the Supreme Court on Cherokee removal. That moment marked a constitutional crisis that took decades to resolve. Noem's defiance follows the same playbook: acknowledge the court's theoretical authority while refusing practical compliance. Goldman's persistence in demanding specifics about court-ordered steps wasn't grandstanding, it was evidence gathering. Every non-answer, every deflection, every personal attack created a record of willful non-compliance that future courts and oversight bodies can reference. When officials claim they're following the law while openly violating it, documentation becomes crucial. The stakes couldn't be higher. Constitutional democracy depends on institutional respect and voluntary compliance with legal decisions. Once that breaks down, power becomes the only arbiter of disputes. Goldman's questioning exposed that breakdown happening in real time, with a cabinet secretary brazenly admitting non-compliance while claiming constitutional authority she doesn't possess.